Good morning, Your Honor. Deputy Gordon Lehman here on behalf of Arbor One, Arbor West.
Alex Henry on behalf of defendant Rico McGuire.
All right. Where are we on these cases?
So in this case, particularly for Rico McGuire, we talked with counsel. I don't think we have any counterclaims in this case. I don't think there's any escrow. At this time, I think both parties would be agreeable just to dismissing the case.
Okay. I don't have a problem doing that. However, what's happening with the rest of these?
Yeah.
And the reason I say that is because when we called the cases, because of the way these cases were filed, I've called it under Rico McGuire, and the other cases came along with it. So
Right. I think at this point, if there's no question of escrow for the tenants, I think in general, we are agreeable to dismissing those cases. So if there's a way for us to find out what tenants still have escrow, I think that could give us a clue.
At the beginning of the hearing, the court session opens with the attorneys identifying themselves. Deputy Gordon Lehman states that he is present on behalf of Arbor One and Arbor West, while Alex Henry appears representing the defendant, Rico McGuire. The judge then asks the lawyers to clarify the current status of the cases before the court. Attorney Henry explains that after discussing the matter with counsel, it appears that there are no counterclaims in the case involving Rico McGuire. He also notes that there does not seem to be any escrow money currently connected to that specific case. Because of this, both parties appear willing to move forward with dismissing the case entirely. The judge responds that there is no issue with dismissing that case, but immediately raises another concern. The judge explains that several other related cases were called together earlier because they were filed under similar circumstances. As a result, the court must consider how those additional cases should be handled before any final decision is made.
Who we have no objection to dismissing and, having a conversation from there.
and do we have that list?
It is not an updated list, but I do.
You don't have an updated list? How long will it take you to?
10 minutes.
10 minutes? Okay. Then I can have that list and we can do those dismissals. Ann tells me 10 minutes. I'll give her 5.
Okay.
And all right. So anyway, we'll get that list of those. What else are we doing on these today?
Yeah, I think we're agreeable that that's probably the best course of action for all the cases that don't have escrow. There are a few tenants here today, I think, that do have escrow. They're going to be trying to request that back, and we may be assisting them in filing a motion to do that.
Okay. So, and I think I'm back at that same spot. Those tenants that have escrow, what in the circuit court, well, there's a circuit court matter, there's a federal court matter, as I'm to understand. But what are those courts saying should be done with the escrow, if anything?
I don't think they're saying anything expressly about the escrow. That does not seem to be a major topic of discussion in any of the ongoing matters. And so I don't think at this point there's any clear directive on what is to be done with the escrow. I know that there was a prior.
The judge continues questioning the attorneys about the remaining cases connected to the same matter. Because the cases were filed in a similar way, they appeared together when the court called the docket under Rico McGuire's name. The judge wants to ensure that dismissing one case will not create confusion with the others. Attorney Henry explains that if there are no escrow funds held for the tenants in those related cases, the parties would generally agree to dismiss those as well. However, he stresses that the attorneys first need to confirm exactly which tenants still have escrow money held by the court. Determining that information would give everyone a clearer understanding of which cases can be dismissed immediately and which ones still require additional attention. The judge agrees that having a clear list would make things easier and asks whether such a list is available at the moment.
A prior process for tenants to apply for release of those escrow, but I understand the court has said there's only been limited number of those that have actually occurred.
Correct. So that process that was in place before, I guess I need to understand, is that still in place and people just haven't used it, or did it go by the wayside somewhere? Because
We're a little confused as to what process Ms. Gordon is referring to.
there was a process by which the tenant would go, as I'm recalling, would go into BO Properties. They had some type of an agreement.
Oh, the move-out
They-
agreement.
Right. They would go in, they'd sign that. That somehow or another got submitted to the court. The court then would release the escrow based upon that.
Folks that had the move-out agreement available to them, the judge didn't sign that order till I think late May. So folks that had moved out before then could not take advantage of that.
Okay. And that's fair. I'm just trying to figure out what then do I do with those tenants escrow who are in that other category?
So
I think
we had a conversation, Your Honor, with Judge Conkey about the 14A District Court escrow. And she didn't say that she was going to order them to be released, because obviously that's in the jurisdiction, but she is in agreement that those should be released back to the tenants if it's for escrow during the period where they had no certificate of occupancy.
Where there was none.
Yeah.
Okay.
And I believe all the escrow was prospective. So none of it should be for a period that was before they lost the certificates, which was in September of 24.
Okay.
I mean, I think
So-
The attorneys inform the judge that they do have a list of tenants, but it is not fully updated. The judge asks how long it would take to obtain a complete and accurate version of the list. One of the staff members estimates that it will take about 10 minutes to gather the updated information. The judge responds with a bit of humor, saying that although the staff member asked for 10 minutes, the court will only allow 5. The light moment brings a short laugh inside the courtroom. Despite the joking tone, the judge emphasizes the importance of getting the correct list so that the court can identify which cases should be dismissed right away. Once the list is ready, the court will be able to move forward with clearing as many cases from the docket as possible and focusing only on those that still require a decision.
procedurally
Go
at this
ahead.
point,
Yeah,
Your
yeah,
Honor, tenants would apply to your court via motion, and it would be in your discretion to determine if you want to release it or not. And we would have the opportunity to respond. I think procedurally, that would be the way in which, if tenants wanted their escrow back, that would have to occur. I don't think there's any other directive other than that.
The court could sua sponte also release it under the circumstances.
Well, here's part of my concern with releasing the escrow. I've had the circumstance that I talked about where somebody was, and I guess it's a move out thing. I got that. But then we also had tenants who paid the money into escrow, but are now in another case, usually at 14B. And so then I would be signing orders and then drafted orders to release the escrow we had here to 14B to hold in escrow because that became their new landlord. And I don't know if we have those cases still out there too.
I don't know that we have any open 14B cases for the current 14A tenants. I believe those cases have all been pretty much settled or resolved in some way.
And we don't handle the Ypsilanti Township side, so we would not be privy to that. But I will say, just based on what Your Honor is saying, it sounds like some of these are different factually and, case by case basis. So I think it would be appropriate to have tenants motion for release of their escrow. And if the court is inclined for whatever reason, based on the facts to grant that, it's in Your Honor's discretion. But I don't think it should be a unilateral release of the escrow without considering all the factors involved with that particular tenant.
Your Honor,
Yeah.
If any escrow was released already to 14B, I don't think that this court would have to worry about that anymore.
Say that again.
If escrow was already released to 14B District Court, why would this court be concerned with how to handle?
Oh, I'm not. I'm not concerned with that. What I'm concerned with is tenants moved basically across the road, but they ended up in Ypsilanti Township. They were there for a while, whatever the agreement of their move-in was and the like. And I understood some of them, and some of them it was difficult to comprehend. But they were there for a couple of months, and then a lawsuit was filed against them by their new landlord, which was typically Beal. And then the tenant would go before Judge Washington's court and indicate that.
After discussing the list, the judge asks what other actions the court needs to take that day. Attorney Henry explains that dismissing cases without escrow would likely be the most efficient solution. However, he points out that several tenants who still have escrow money are present in the courtroom. Those tenants may want to request the return of their funds. According to Henry, they might need help filing formal motions asking the court to release the escrow money back to them. The judge acknowledges this possibility and begins thinking about the proper legal process for handling those requests. The court must be careful because the issue of escrow money can become complicated, especially if there are other legal cases or jurisdictions involved.
That they have money in escrow. So then they had to get the money from here to 14B. In at least one of the cases, that was to comply with an escrow order that had been entered there. The other was just sent over and held in escrow at 14B. What I'm getting at is I don't know whether or not those cases still exist.
I think Mr. Henry's addressed that.
To my knowledge, I don't believe any of those exist at this time. But I can't speak for all the cases.
You're right. And I think that's part of the problem. So I've got, I have this here and it's all just a mess, quite frankly. But I think I'm going to agree with plaintiff's counsel that I'm going to have motions by the tenants. I don't think they have to be anything extensive.
Your Honor, we have promotions. Actually, Mr. Henry drafted some already that are ready to go.
We'll do our best to get those to the tenant so they can get those into.
There are, I believe, 3 or 4 tenants that we don't have contact information.
Pardon?
There are some tenants who have escrow that we do not have contact information.
Okay.
And you probably know that there was no mail at Arbor One for quite a while. I don't know what people did to forward their mail.
Well, if I get all of these down to 3 or 4 cases, I will be happy. Bless you.
And I will tell you, Your Honor, just so you're aware, to my knowledge, there's only one tenant on their current docket that is still actually in their unit. Everybody else, according to my records, has been accounted for as no longer being in their original Arbor 1, Arbor West unit. Arbor 1, outside of 3 buildings, is completely vacant. Arbor West, to my knowledge, there's 3 or 4 tenants that still remain, but they will be vacating or transferring by at least mid-month. We have 3 buildings that now have COCs, permanent COCs that are online. And so tenants have been placed in those. And so to the extent that there is a concern of folks actually still being in their units on your docket, that the one tenant, I believe, should be out mid-month. So there will be nobody.
So the one that is, just so I'm clear, the one tenant that's on my docket that is still residing there should be vacating mid-March or so.
Yes, that is my understanding. Yes.
Okay.
And Your Honor, I don't believe he has any escrows. So I don't think the case can still be dismissed.
Correct. Yes.
Right.
Yes, absolutely.
I get that. Okay, so at this point, Mr. How many motions regarding escrow are you anticipating? Do we know how many we have?
Yes, I have 10 cases in escrow. Do you want to know?
These are the 10.
Mm-hmm.
I think we've been able to get in contact with 8 of the 10 that have escrow.
Are you? I know. Are you sure that we're okay? I just want to make sure. Are we talking about the same people?
I believe so. I can name them if that helps.
Go ahead.
Natasha Drake.
Well, why don't I do this? Because you've got your list and I've got my list. I think that's going to be in numerical or alphabetical order. I have Tashanti Cloakley.
Yes.
You got that one? Rhonda Chambers.
Yes.
Austin Vance.
Yes.
Jennifer Cook.
Yes.
Sharon Carson.
Yes.
Scott McDonald.
Yes.
Erica Reed.
Yes.
Andrew Miller.
Yes.
Lawrence Grove.
Yes.
And Natasha Drake.
Yes.
Those are all the ones I have.
To be clear, we don't have contact with Deshante Coakley and Rhonda Chambers.
Got it. So
What
we
was
don't.
that? I'm sorry. What was that first name you said, Alex?
Deshante Coakley.
Oh, okay.
Tishante.
Gotcha.
You don't have contact with that person, right?
Yes.
And who else?
Rhonda Chambers.
Okay, my first two. The other ones you have contact with and could file those motions, right?
The judge turns the conversation toward a bigger legal question involving the escrow funds. The court asks whether there are any ongoing cases in circuit court or federal court that might affect how the escrow money should be handled. The judge wants to know whether those courts have issued any instructions about what should happen to the funds. Attorney Henry responds that, to his knowledge, the other courts have not given any specific direction about the escrow issue. He explains that the subject of escrow has not been a major focus in the other legal proceedings. Because of that, there is currently no clear instruction telling the district court exactly what to do with the funds. This lack of guidance creates uncertainty for everyone involved in the case.
Any of these, and again, this gets a bit confusing for me because they moved out. So you're going to be proposing that the escrow be released to them,
Yes.
right? Not to their landlord, their current landlord, or anything along those lines.
Directly to the defendant.
So how many people are here right now? 1, 2, 3, 4, 5. Well, hold on. Are you guys together or are you?
No, I don't know him. We're just related.
Pardon?
I don't know him. We're just related. we're separate cases. So I'm Austin Vance Grove, and this is Lawrence Grove.
I don't know him, but we're related.
Welcome to what?
No, I'm gonna tell you, I have some cousins like that. Where I will tell them but I don't know them, but we're
I
related.
have a brother like that. He's right here.
Okay.
We don't really.
So there are three separate cases. Right?
We're
Two separate cases.
two separate cases. We're Austin Vance and I are in the same unit. That's my boyfriend.
They do have two.
Remember you called him annoying 6 months ago? It was great. I loved it.
What? I called somebody annoying?
Yeah, you called my boyfriend annoying. It was great. You just confirmed what we already knew, okay?
I'm glad I could make you happy. All right. So, and this gentleman over here, what's your name? Mr. Hicks. Okay. I don't have any escrow for you.
Mr. Hicks does not have escrow. That is correct. Neither does Mr. Mustafa Hadake, who also raised his hand.
So those cases are going to be your case and who else?
Mr. Mustafa over here. on the left.
Okay, so those are going to be dismissed, right? I think everybody's in agreement on that. All right. So you have a form motion but I have how many? I have 3 tenants then that are here. Is that right?
3 tenants with escrow.
With escrow.
Yes, I believe so. Mr. Miller and Groves.
And Miller is here.
Okay, so I have those 3. All right.
Files are for those.
Well, yeah, what I'm going to do is I'm going to step off and what I'd like to do is I'd like to get rid of as much as possible. So those cases that are going to be dismissed, I'd like to do that on the record. We'll have to sort them out. Right. And then the ones, I guess if counsel, would you waive, because I'll set another date, but the 3 that are here, I don't know if there's going to be any objection to the escrow that's there to be released.
It's not clear to me who's there, Your Honor.
Okay, very good. That's fair. Who do you have? Who's
That'd be Elisa Grove for the Austin Vance case.
Grove for the Vance case?
They've got 2 cases, but escrow's posted in 1.
I have Austin Vance.
Yeah.
She's only listed on one of the cases. I believe the escrow is in the case just in his name.
Right.
Yeah, then there's Lawrence Grove, also has escrow.
Lawrence Grove. This isn't making any sense. Okay, I have Grove. Where's Mr. Grove? Right there. Okay. And then let's go back to the Vance case. Who's here on behalf of Vance? And your name?
Elisa Grove.
But
My name is on the lease that they didn't have. This was the whole thing before.
but the case, here's going to be the problem. The case that holds the escrow.
Is Austin Vance, yeah.
Yes. So that motion's going to have to be filed because that's the only way it could be released is to him.
Okay. The motion is in his name as well.
Pardon?
The motion is in Austin Vance's name.
I regave her a motion to
Okay. All right. Very good. And then who was the other one?
Andrew Miller.
And Your Honor, could you confirm how much are in those 2 escrows?
In Miller, you're talking in Miller and Grove?
Correct, Your Honor.
All right. Yes, I can do that. In Miller, there is $1,516. When you put AO up there, they deposited that.
That was from Arbor One, correct?
Right. So that was from Arbor One, but it was rent that was paid in.
Correct.
The tenant paid the rent, but Arbor One deposited the escrow
Okay.
on that one. And that's on Miller. So there's $1,516 in Andrew Miller's escrow. And Grove, the defendant deposited this, there's $820.
Okay.
Okay, so if there's not going to be an objection, I think I can take care of those two at least today. The other ones would have to be filed. And so what I'm going to do is give my staff a chance so I can dismiss those that I can dismiss. Do you have orders on the escrows? Proposed orders?
I think I do have those, yeah.
Okay, so I would accept or at least look at proposed orders on Miller and Grove.
And Your Honor, I can't affirmatively say at this point that we wouldn't object. Now that I know who they are and how much is in their escrow, I will.
You would be objecting on
I
what
need
grounds,
to.
I guess.
I need to inquire with the property management team directly now that I know who these individuals are and how much is in their escrow. I think there's always been a question of arrears prior to the non-COC period. So I think if there were
Prior to
arrears,
the time.
yes, I think that would be a question that I need to confirm on these specific tenants. And then I could advise the court whether or not we would be objecting.
Okay, then let's do this. Let's do it this way. I was hoping to try to clarify those if we could. So I'm going to let my staff organize the files so I can get rid of what I can get rid of. Then with regard to the motions, are you prepared to file those motions today with the exception of the two?
For all the other tenants?
Yeah, for those that are going to be left, are you prepared to file those today?
I'd have to get in touch with those tenants because we don't represent them in court. So we'd have to get those to them and then have them send those in.
Wow. So
The judge recalls that there used to be a process allowing tenants to request the release of escrow funds. In that earlier system, tenants would visit the property management office and sign an agreement related to moving out. That agreement would then be submitted to the court, and based on the documentation, the judge could authorize the release of the escrow money. However, the attorneys explained that the situation was complicated because the judge did not approve the official order for that process until late May. As a result, tenants who had already moved out before that time were unable to take advantage of the system. The judge acknowledges that the explanation makes sense, but still wants to determine how the court should deal with tenants who fall outside that earlier process.
but if you give them that motion, so you're not representing some of these folks, right?
That's correct. We can, but we just have not put in an appearance yet.
Yeah, okay. Well, this is going to be a little bit difficult in terms of scheduling it, because the motion's going to have to come in, give plaintiff an opportunity to look at what claims they might have, and then the court's going to have to be able to look at that and rule on it. All right, all right. How long will it take you think, to get in touch with these individuals to get either an appearance entered or some authority to be able to file a motion?
I think we should be able to do that by the end of the week.
By the end of this week. Okay. Better than what I thought. So I don't have a Tuesday until April 14th.
No, sir, you have the 10th and you have the 17th of March.
Right, but
And then after that, correct, not until April 14th.
okay. And counsel, after you get it, you'll be able to get in touch with your client as to where your claims may be regarding these, correct?
Correct. Yeah, we
I
would
mean-
need to look at each one of these and kind of figure out what's going on with that particular tenant.
The discussion shifts to tenants who placed money into escrow during a period when the property allegedly did not have a valid certificate of occupancy. According to the attorneys, another judge had indicated that tenants might be entitled to receive that escrow money back if the funds were paid during the time when the buildings lacked proper certification. The judge listening to the case clarifies that although the other judge expressed agreement with returning the funds, she did not directly order the district court to release the escrow. This is because the matter falls under a different jurisdiction. The attorneys also point out that all the escrow funds were deposited after the certificates were lost in September 2014, which could strengthen the tenants' arguments for receiving their money back.
Tenant in their ledger and account to determine if there's any basis to object. And so
do you have, counsel, you don't have the list of who we have escrow on? Is that correct?
other than Your Honor, just reading the list of those 2, 4,
Those names?
8, 10 names, I don't have anything else formal. And I
And-
don't know what
and
would be
you-
in those other tenants' escrow accounts either, amount wise. So
Gotcha. Okay, that's what I was trying to get at. And you guys don't have the amount of escrow for those.
I think we do, for maybe everyone except Tasha Drake, which may be out of date.
Okay, so here's what I'm going to do. I'm going to, if you can have these in before the end of the week, I'm going to set these for escrow hearing on escrow for March 17th. Because otherwise I'm not going to have anything till mid-April. So I'm going to try to do this as quick as we can. But that means the motions have to be in. Counsel, if you end up in a circumstance, certainly we would like a written response, but I will take and address any oral objections that you have
okay.
because of the limited time frame. So I'm not going to hold you to try to get something in writing specifically, but I would try to deal with any oral objections that you'd have to release of the escrow.
And Your Honor, I apologize. What time would the 17th be? I have a deposition scheduled that date.
Do you? What time's your deps?
My deposition starts at 12 o'clock in person in Troy.
Okay, so let me set this at 9, and can you put on there? We'll get in and address these right away to get you out of there. Okay.
Thank you, Your Honor.
And what we will also do, counsel, is I'm going to have my staff. So while they try to arrange all the dismissals, and then I'll come back out, we'll dismiss those cases. I'm going to have and send over to you our printout with the escrow amounts on them so that you can see that for each of the tenants.
Perfect. Thank you, Your Honor.
All right. Now on them so that you know, so this is their marking. There is, after each number at the top, you'll have AO or you'll have defendant. Those where it's AO is where Arbor One received rent, but then under my order paid it into the court.
Okay.
All right. So that's the only distinction. So, Ann, let me give these back to you. And then you two can arrange all the dismissals so I can get those done. And then we can do that. So I'll pass this matter. So hopefully we can at least get something done on these today. Oh, Mr. Hamden has come back into the room. Can you get Ms. Vitale and Mr. Hamden to the jury deliberation? And then I'm going to step off, meet with them, and then I will come back. I promise.
Thank you.
Maybe. But, all right. Thank you, folks. So I'll step off.
Despite that explanation, the judge remains cautious about releasing the escrow money automatically. The court describes situations where tenants moved out of the properties and later became involved in new cases with different landlords. In some instances, the escrow money had to be transferred to another court because it was connected to a separate legal dispute. The judge explains that there were cases where tenants moved to nearby housing, ended up in another jurisdiction, and then faced lawsuits from their new landlords. When those tenants appeared before another judge, they claimed they already had money held in escrow in the current court. That situation forced the court to transfer funds to another court so the money could remain in escrow there. Because of these complicated situations, the judge wants to ensure that releasing funds now will not interfere with any other legal obligations.
4505. 504. So this one.
Who is that?
So this is Arbor 1 versus Edwina Freeman. She should be a dismissal. She does not have any open escrow.
Okay.
So I
So,
think
you know what? On your list,
Yep.
you just flipped them. That's what happened.
This one.
So Edwina Freeman, that being the case ending in 4222, is a dismissal. And that will bring my
Back to
1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Yes.
Yes, we have.
The attorneys respond that, to the best of their knowledge, most of those related cases have already been resolved. However, they admit they cannot guarantee that every single case has been closed. The judge acknowledges that uncertainty is exactly what makes the situation difficult. The court explains that the entire collection of cases has become confusing and disorganized over time. Because of that, the judge decides that the safest approach is to require each tenant to file a motion requesting the release of their escrow funds. These motions do not need to be lengthy or complicated, but they will allow the court to review each situation individually. By handling the cases one at a time, the judge can ensure that no legal obligations are overlooked before releasing any money.
I have 10 on my list for the 17th as well. So
You have 10.
I have 10.
You have 10. Everybody's got 10. Beautiful.
Going with the 10.
And as long as they're the same 10, we'll be good.
You know? Hopefully. And is Your Honor entering individual orders or one order for the dismissals?
We will be, how are we going to prepare those?
I'm assuming orders are to follow.
Yes, or we can do the dismissal. We'll just do one general dismissal with all those on it.
Okay.
All right. Okay. We will take care of that.
Okay. Sounds good.
All right. Thank you. Appreciate
Thank you,
your
Your Honor.
patience and waiting while I
Of
was
course.
doing that. All right. Well, we'll see everybody on the 17th.
Thank you so
Take
much.
care. All right. That's it for us.
All day, yes, sir.
The attorneys inform the judge that they already have draft motions prepared for some of the tenants. They plan to distribute those documents so tenants can file them with the court. However, there is another challenge because the attorneys do not have contact information for several tenants who still have escrow money. The judge notes that communication has been difficult because mail delivery at Arbor 1 was disrupted for a long period of time. Despite these obstacles, the attorneys estimate that only about 10 tenants still have escrow accounts connected to the case. The judge expresses hope that if most of the cases can be dismissed, the number of remaining disputes will shrink to only 3 or 4. The attorneys also informed the court that nearly all tenants have already moved out of the buildings, and the last remaining tenant is expected to leave by mid-March, which should help bring the long and complicated situation closer to an end.